Well, hello everyone, and welcome to One Civil Law. I hope you're having a great day. And for a story that I did not expect in my day, the armorer, the gun supplier, the ammo supplier, relating to the movie Rust from the Alec Baldwin shooting. We remember all that. The guy who supplied the ammo house, has decided to go pro se and sue everyone in sight. This is great. This is fantastic news. I have not read any of this lawsuit at all. I did go to the end to make sure it was pro se because I couldn't believe it, and it is. He filed it himself, pro se. This does not seem like a good move on any level. I think everyone sort of forgot, about everything and it's moved on, and I'm not really thrilled about any causes of action. The only thing I could think of off the top of my head where this guy would have a cause of action is basically other people's negligence ruined his business. So because, of course, it wasn't his ammo, don't you know, right? He only supplies the bestest, most reliable movie prop ammo. So he's got unfairly tarnished by the actions of others. So some sort of business defamation or tortious interference, maybe, if everyone did it deliberately. I mean, I'm struggling here. I'm struggling here to think of causes of action. And even if you had causes of action, do you really want to bring it at this point? I mean, it's been a hot minute since the Rust shooting. Do you really want to bring this and revivify all that at this point? And also the fact that you couldn't apparently find an attorney to represent you is not, that's not really a promising sign. So I'm going to review this. I've not read any of this lawsuit, but I'm looking forward to it. This is exciting. He puts his name and address right on the top corner there. And that we are in the State Court of New Mexico in the First Judicial District of the County of Santa Fe. And the case is Seth Kenney and his companies, which, by the way, right away, the lawyer in me is like, I don't know if you can do that. I think there's only a few states in which you can do that, in sort of a pro se, because the company is a corporate entity, right? The corporate entity is a person. That's the whole point of creating the company. They are fundamentally a person, right? So a pro se typically cannot represent a company because a pro se can represent themselves, but the whole point is the company is not themselves, right? So there are like a few exceptions, I think, but most of the time you need an attorney to represent the entity. So right away, I have questions on whether or not he can file this on behalf of his company. And even if he can, whether that's a good idea or not, because it gets into blending things, but never mind. Seth Kenney and his companies would like to sue Rust Movie, Alex Baldwin, and literally everyone else in sight. Also does 1 through 100. That's exciting. Okay, and then comes now. This is just wrong. Comes now plaintiff, an individual, and then the company who complain against who writes this? No one does. Okay, all right, never mind. Introduction. Plaintiffs are in the business of supplying props to film productions, including the rentals of firearms, cosmetic dummy rounds, technical props, blank ammunition sales, and armor set services. Plaintiffs have safely and without incident provided firearms, blank ammunition, and dummy rounds to approximately 1,000 highly rated feature films, television episodes, historical reenactments, theatrical productions, and volunteered goods and services for local, state, and federal agencies' active shooter training. Okay. Plaintiffs rented their personal firearm property to defendants for the use in filming of Rust. Film sets have strict guidelines, well, one would hope, but maybe not so much, for the use of firearms, blanks, and dummy rounds on film. Also, is that an assumption of yours that they have that, or is that like in your contract? Right? Do you insist that they have that, or are you just hoping they do? Right? Because, moving on. Plaintiff's firearm rental property was in good working order, and plaintiffs rented to defendants under provisions of the strict film safety guidelines and practices. Did they tell you that those were the practices they were using? Did they make an affirmative representation? Was it part of your contract? How is it part of this agreement? and with understanding defendants will observe and comply with local, state, and federal law. You can assume that they will comply with the law. That's a fair assumption. You can go with that. Defendants knew plaintiff's firearms rental property was to be loaded only with dummy rounds and blanks, never live ammunition. When you say knew, is that part of the deal? Is that part of your contract? What do you mean no? Did they tell you that? Was that part of what? Defendants individually and collectively violated the rental agreement by allowing the loading, illegal concealment, and discharge of a live round of ammo from the rental property. So you seem to be implying, although not necessarily outright stating, that putting live ammo in there is a violation of your rental terms? Is it? It'd be helpful if you stated that explicitly. Also, are you going to provide us a copy of the agreement at some point? That'd be nice. Defendants individually and collectively breached animal welfare standards. One, how? Two, why does it matter? And the rental agreement between defendants and plaintiffs and did commit animal cruelty. What the hell are you talking about? An illegal act using plaintiff's firearm rental property for financial gain. What the fuck? Defendants individually and collectively chose to misuse plaintiff's firearms rental property for cost-cutting financial gain resulting in animal cruelty, injury, and death. What animal cruelty? Did I miss a memo? What is they talking about? Defendants collectively and individually benefit financially from use and illegal misuse of rental property, and to date have failed to remit payment for the rental of the property. Okay, so that's a standard breach of contract claim. Okay, fair enough, I guess. You didn't get payment in advance or something? All right. Defendants individually and collectively in an effort to distance themselves, and also incidentally, the breach of contract would be with whoever the contract was with. So who was the contract with? Who? That's the party you sue, the other person of the contract. I promise you that all these people that we sued are not parties to the contract. Okay. Defendants individually and collectively, in efforts to distance themselves from the Rust criminal investigation and onslaught of negative publicity, conspired to paint plaintiffs in a nationwide false light scapegoat smear campaign and falsely alleged that plaintiff possessed Theo Reed's 1883 reloaded .45 Colt ammo, made its way through plaintiffs into the set of Rust, and therefore contributed to death and injury. So we're going with I guess we're doing defamation against the business? Okay. I'm not even 100%. All right. Defendants individually and collectively knew or should have known, like any reasonable person, that broadcasting completely false narrative associated with death and injury would be, yeah, we're going with defamation. Okay. Would be highly offensive to a reasonable person and cause egregious financial drama and trauma to the plaintiffs. So we're going with negligent or intentional infliction of emotional distress. I don't know. I'm confused. This introduction is not helping me. What are we doing over here? Okay. The totality of defendants' acts, individually and collectively, has caused plaintiffs ruinous financial loss, injury to reputation within the film community, and public at large, severe emotional distress, and significant loss of past and future stuff. Okay. All right, then we get the parties, which, whatever. I don't care. They're going to go on listing the parties for a while, whatever. There's still, okay, wait a second. Are we still doing parties? This is the longest listing of parties I've ever seen in my life. How? You're talking about this is going on for a while. This is going on for a hot minute, man. We're still talking about the parties 4 pages later? Damn. Okay, still going. Still going, still talk. Wait a second. Did we move? Okay. All right. I object to this on formatting wise. This means we actually have to read this all. I object to this all because it seems we have mixed in arguments into the listing of the parties. So, okay, guys, look, when you list the parties, it is literally like, who is this person? That's it. That's all it is. It is nothing more. It is nothing. It is not complicated. Okay. It is a sentence. Like, okay, Alec Baldwin is an individual who lives in California. End of sentence, right? That's it. That's all you'd have to say. He seems to have mixed in allegations and argument into his party section. So I guess we have to read this now because it's all together in one moosh. Fine, we'll read it. God help me. Fine. Plaintiff City, South Kinney was at all relevant times a resident of Arizona, was the owner of PDQ Arms and Prop, Arizona, and PDQ and Arms, New Mexico. Plaintiff PDQ Arms, and also incidentally, like, whether or not he can represent the LLC might also be determined by the relevant law of not only this state, but other states too. Because now we've got multiple states involved. Okay. Trying to figure out whether or not okay. I'm just going to assume that he can't represent the corporate entities because that's the safest assumption. Plaintiff PDQ Arms and Prop is a limited liability company in the state of Mexico, owned and controlled by plaintiff. Well, you just told me that a sense ago. Plaintiff PDQ Arms and Prop is a limited liability in the state of Arizona, owned and operated by a plaintiff. Okay. Why do you have two registered LLCs to do the same thing? That's odd. Why are you registered in both states? That doesn't make sense. And if it does make sense, which business was it that was in contract? Right? Because if it does make sense for you to have two separate LLCs, then they're different people. So which one was doing what? Oh, God. Plaintiffs are informed and believe in thereon defendant Rust Movie Productions. It's a domestic limited liability company organized and existing under the laws of the state of New Mexico, with its principal base of business in Thomasville, Georgia. Plaintiffs are further informed and believe and allege therein that Rust Movie Productions was organized to produce the film Rust. Sure. Plaintiffs are informed and believe and allege therein defendant Alexander R. Baldwin is an individual at all times was a resident of New York. You don't have to say other things, by the way. You could just say he lives in New York. That's where that should have ended. And also, by the way, you don't really need to say informed and believed and allege. That's really unnecessary wordage here. It's totally unnecessary. And it's just verbose for the sake of being verbose. Just plaintiffs, and also you don't need to say any of this. You don't need to say any of these words here. You could just say defendant Alex R. Baldwin, an individual, was reside in New York, period, and move on to the next paragraph. But no, we're not going to do that because we can't have nice things. Plaintiffs are informed and believe, and thereon allege he's going to kill me, isn't he? That defendant Baldwin was an actor in and producer of the film Rust, and in relevant times contracted as an individual or in his official capacity with a loan-out corporation, defendant El Dorado Pictures. Defendants endorsed to provide services for the filming of Rust. Plaintiffs are informed to believe and allege thereon defendant El Dorado Pictures is a corporation incorporated and existing under laws of the state of California with its principal base of business in California, period, and no further words, but no. Plaintiffs are informed and believe and allege thereon that El Dorado Picture was the loan-out company for defendant Baldwin's related to filming. Again, you don't need to state this in the party section. The party section is only literally who are these people. You don't. Plaintiffs are informed, believed, and alleged they're on defendant Ryan Dennis Smith, an individual at relevant times. And also, by the way, you could just say that once, by the way, if you really wanted to do that, you could just say, like, if you really wanted to say this, which I don't think you really have to anyway, but instead of repeating it in every paragraph, just say it once. Just say, plaintiffs state the following based on information and belief. And then you don't have to say it every single paragraph. Also, we kind of know that that's what you're doing because, yeah, you don't, yeah, all right. Where was I? Defendant Ryan Smith is an individual at relevant times, was a resident of California. Plaintiffs are further informed, believe, and thereon allege that defendant Smith was a producer of the film Rust and at relevant times contracted as an individual or in his official capacity with defendant Thomas Pictures LLC defendants and or Doe's for the producing of Rust. Plaintiffs are informed and believe and thereon allege that defendant Ryan Donald Smith, an individual, is at relevant times a resident of California. Plaintiffs are further informed, believed, and thereon allege that Smith was the producer of Rust and times contracted. Plaintiffs are informed, believed that defendant Casey Bradstein is an individual with an address unknown. Okay. Plaintiffs are if you don't know where he lives, getting him service is going to be a challenge. Plaintiffs are further informed and believe and thereon allege that defendant Bradstein was, without limitation, a co-producer for the film Rust and at all relevant times contracted as an individual and or her official capacity with then defendants or Doe's 1 through 50 provide services for filming. Plaintiffs are informed and believe and thereon allege defendant Tyler Gould was a resident of an address unknown. Plaintiffs are further informed, believed, and thereon alleged defendant Gould was without limitation an executive producer for the film Rust and at relevant times contracted as an individual and or her official capacity with defendants and or Doe's 1 through 50. Okay. You don't mean official capacity. You mean like corporate capacity or something, right? Official capacity is usually language you reserve for government actors. Okay. Plaintiffs are informed, believe, and thereon allege that defendant Matthew Hillman, an individual, was at relevant times a resident of address unknown. Plaintiffs are further informed, believe that defendant Hillman was, without limitation, executive producer. Plaintiffs are informed and believe. If he says informed and believe one more time, I'm going to punch him in the face. We know. I got it. Plaintiffs are informed to believe and allege thereon the defendant Hill was, without limitation, executive producer for the film Rust and at relevant times contracted as an individual with defendant Doe's. Plaintiffs are informed, believe, and thereon allege defendant Luke Taylor, an individual, is at relevant times was an address unknown. Plaintiffs are further informed, believe, and thereon allege that defendant Taylor was, without limitation, executive producer Rust contracted. Plaintiffs are informed, believe, and thereon allege defendant. All right, I refuse to read this all. I'm just going to skim it and see if there's anything that I care about in this. Dean is a financer. Cheney is a producer. Thomasville Pictures is a liability company in Georgia. Defendants are informed, believe the defendant Najem is producer of Rust. Plaintiffs informed, belief, and thereon alleged that Brittany House Pictures is a business form unknown from defendant Brittany House Pictures. Rust. Hannah Gutierrez Reed further informed that Reed was, without limitation, the armorer, which has a capital A for some reason. Plaintiffs are informed, believe that defendant David Halls, an individual, was a resident of the state of New Mexico. Defendant Halls was assistant director. Nathan Kliger was a producer. I'm losing my mind. I'm going back to skimming. Defendant Calvary Media is a corporation in Delaware, was a loan out company. Defendant Pickle, Gabrielle Pickle, Lion producer. Are we really just suing every single person in the entire picture? Okay. The judge is going to throw this out. Yeah, probably. Catherine Waters is Ray of Peasant Pena, unit production manager. Okay. You do realize you have to serve all these people. If you don't know where they live, how are you going to serve them? That's a good question. This is a lot of people to serve. Service is going to cost a bit. New Mexico, relevant to California. Okay. The true names and capacities, whether individual, plural, corporate, partnership, etc., otherwise are unknown, inclusive or unknown to defendants or plaintiffs, who therefore sue said defendants by fictitious names. Though defendants include without limitation producers and or financiers relating to the film movie Rust. If you can tell me how the financier of Rust could even theoretically have anything to do with this, I will give you a cookie. How on God's earth is the financier of Rust involved in this story? The full extent of facts linking such fictitious sued defendants to unknown as plaintiffs. Plaintiffs are informed, believed, and therein alleged each defendant designated herein as co-defendant was and is liable for events happening therein, intentionally, recklessly, and or without cause or excuse, and utter disregard some manner. Plaintiffs will hereafter seek leave of the court to amend. Plaintiffs are directly liable for their own negligent acts. That's deep, thanks. As well as the negligent acts of their officers and directors acting on their behalf. Sure. Defendants are also vicariously liable for the acts of their employees. Maybe. That's standard law. Plaintiffs are informed, although at this point, I'm not even sure I believe in standard law at this point because you're broken my spirit. Plaintiffs are informed and believe, alleged at times, defendant was the agent, ostensible agent principals. You can't be both. That's good. You're both an agent and a principal. That's nice. Joint ventures, servants, employees, employers, co-conspirators, and joint ventures of their co-defendants. Each defendant shared a community of interest in the object and purpose and undertaking of producing and creating the film Rust. I suppose that much is true. Each had a substantial or equal right to share in the control of design. Really? You think every single person had an equal right to control the design of the movie? Okay. And rights to profits. I'm sure that's how it works. I'm sure everyone is an equity partner and equal shares at that. Regardless of whether such right was actually exercised, defendants control the administration, planning, management, and quality control of the product of Rust. Defendants control include, without limitation, control of marketing, accounting. How does accounting enter this picture? Oh, Lord. Human resource management, training, staffing, creation, implementation of policies and procedures, safety assessment and compliance with regulatory and industry standards, licensing, certification, hiring, supervising, training, and managing of the employers and agents used in production. This is going to get dismissed on a motion to dismiss so fast. There's no fucking way. I'm not, as a judge, I'm like, no, just no. I'm not doing any of these things. No, I'm dismissing this so fast. It's like not a chance. No, just no. Defendants operate a joint venture for the purpose of increasing profitability and pursuing their similar business interests and collectively controlling the production staffing Rust. Because all defendants were engaged in a joint venture enterprise before and throughout the use of the firearm property, really? Wow, that's interesting. The acts and omission of each participant in the joint venture are imputable. The firearm binds them all. The firearm has become the one ring. That's cute. The actions of each participant and each participant's servants, actions, employees, and joint ventures set herein are imputed to each participant. In addition to direct liability, they're vicariously liable. Yeah. Inform believe that each defendant's clause is responsible for unlawful conduct and resulting by, among other things, personally participating in the conduct at issue in this lawsuit, or acting jointly in concert with others who did so acquiescing, ratifying, or failed to take actions by promulgating policies to which the tortious conduct occurred, by failing or refusing with deliberate indifference. I honest to God want to know how he wrote this. This is like, I don't even know how he wrote this. This is just like, I mean, the only way that this sort of makes sense, the way this sort of makes sense is he must have gotten himself like 20 lawsuits and just like copied the verbiage out of all of them and mushed them together. That's the only way this makes sense. Otherwise, I honestly don't know how he wrote this. There is no fucking way, Nexus. There is no fucking way this was written by ChatGPT. ChatGPT is smarter than this. I'm calling bullshit on that theory. Not a chance. Not a chance. To initiate, maintain adequate supervision, retention, and training, and ratifying the equal, illegal, and unauthorized conduct that occurred by employers, joint ventures, agents, and or ostensible agents under direction and control. Whenever and where is reference made this complaint by any such defendant, such allegations referenced shall also be deemed to mean the acts and failures of each defendant individually, jointly, and severably. Sure. Okay. Now, at this point, I'm asking myself the question: do I like actually read the remainder of this lawsuit, or do I just try to skim to anything that matters? Because, all right, I'm in it for the pain. I'll read it. On the film set of Rust, defendant Gutierrez Reed loads a lethal round of live 45 Colt ammo into plaintiff's movie rental property. Gutierrez Reed's walks, why the present tense, into the Rust church set and hands plaintiff's rental arm to the first assistant director, David Halls. David Halls was standing in while defense inside the church waited on David Baldwin. Defendant Halls and defendants chose another stopgap measure to save time, as defendant Baldwin was late to set after a lunch break. Defendant Gutierrez Reed hands the firearm to defendant Halls and instructs him to call her on the radio when defendant Baldwin enters the church for a final safety check of her firearm. This is an offense to the English language. After handing the firearm to defendant Halls, she then exits the church to smoke outside, while defendants inside the church wait on defendant Baldwin's arrival. A few minutes after defendant Gutierrez Reed exits the church, and unbeknownst to her, David Baldwin arrives inside the church to rehearse the scene. Defendant Halls calls out for those inside the church, cold gun, and then proceeds to hand plaintiff's rental property firearm to defendant Baldwin. Defendant Baldwin conceals the loaded firearm into plaintiff's rental property, a leather cross-draw holster that Baldwin is wearing, conceals, and sits on the church pew, hiding the gun beneath his coat and folded arms. Because that's how that's the movie. Defendants individually and collectively within the church agree to go off script with plaintiff's rented firearm and fail to notify both the armorer and plaintiff's employee agent, Sarah, of their Sarah doesn't get a last name here, of their cost-saving, corner-cutting decision, and once again break the standards of firearm safety set on the set of Rust. Again, what standards? Why are you assuming these are standards? Is this hearsay? No, this isn't hearsay. I mean, this part is pretty well established. I mean, this part is pretty well documented. I mean, so it's not hearsay, and that's not how that works. No, it's just I just don't know how it matters yet. Defendants inside the church, individually and collectively, observed defendant Hall as a member of the crew not authorized or qualified to handle guns, including plants property, to do just that and arm defendant Baldwin with a deadly weapon. Upon information and belief, defendants, as veterans of the film industry, knew or should have known defendant Halls was not authorized or qualified to handle firearms on set. Defendant Baldwin stated in a nationally televised interview with George Stephanopoulos, "It's the actor's responsibility is to do what the prop armor tells them to do, and Hannah would hand me the gun 99% of the time." Defendant Baldwin also recounted being told by a previous crew of their firearm safety duties. "My job is to make sure the gun is safe, and then I hand you the gun and declare safe." Defendants knew or should have known that members of the props department were the only personnel authorized to declare a gun safe, and the only members to distribute firearms to actors and stunt persons on the set of Rust. Okay, like, even if all that's true, how does it injure you? How does it injure you? Why is it relevant to you? I'm not sure yet. Defendants knew the rental of the firearms required a 100% alignment with state fire marking standards. How did they know that? How did they know? How did defendants know the rental of the firearms required a 100% alignment with filmmaking standards? How did they know that? Was it in your contract? Did you tell them? Did you hear them say it? How do you know they knew that? You can assume their knowledge and you can assume their knowledge and 100% alignment with the law. That you can assume, because ignorance of the law is no excuse. But how it requires alignment with safe filmmaking standards is not necessarily clear. Defendant Dave Halls was the only one authorized to reiterate and broadcast on the radio and not speak in lieu the props department declaration that our firearm is cold or safe. Upon information and belief, defendants knew or should have known, at a bare minimum, at this point, I am very tempted to take this into ChatGPT and tell me to de-stupefy it. Maybe it can explain to me what the hell is going on. Upon information and belief, defendants knew or should have known at a bare minimum, as outlined by defendant director Joel Souza's email, the actors were an integral component of the firearms safety check, and at a bare minimum, witness members of the prop crew demonstrate the condition of the firearm unloaded or to specify what's loaded with. As Rust director, defendant Souza director had the opportunity and authority to necessarily enforce his prior instructions. On October the 8th, 2021, defendant Souza wrote, "Rust production crew, I'd also like everyone to be told how they are to act around the horses. And I'd like to make sure every time an actor is handed a weapon, they are shown clearly this is either empty or loaded. Defendants collectively and individually could not be bothered to enforce their own safety on set. Upon information and belief, defendant Baldwin was handed a gun by defendant Halls, and without being part of the mandatory safety check, drew plaintiff's rental firearm from the concealed cross-draw holster, swung the firearm across his body, swept defendant Mamie Mitchell with a firearm muzzle, pointed forward, maneuvering the gun directly at Haley and Hutchins and defendant Joel Souza as they looked down and away from Baldwin. Defendant Baldwin knew where he aimed the gun as he looked down the barrel, the deceased and injured. Defendant Baldwin allowed the hammer to drop from the cocked position to a deadly and injurious effect. Upon information and belief, defendant Baldwin is the son of a United States Marine Corps firearms instructor and decades-long high school gun coach. So because your daddy did something, that means you're good at it, I guess? I don't know. Defendant Baldwin was raised with firearms and trained never to handle or manipulate a firearm that may risk its just charge without a proper inspection. Upon information and belief, defendants knew there were the parties to ongoing investigations on set. Complaints in self and career were unheeded by defendants. A result, earlier in the morning before deadly shooting, nearly all defendants' camera crew resigned. Sadly, the head of the criminal department was, in fact, director of photography, Hala Hutchins. All right. Why is it sad? I can't believe I'm here. I can't believe I'm here having to give tips. But he says, sadly, the head of the camera department was, in fact, director of photography, Hala Hutchins. Okay, why was it sad? Just touch me in the morning and walk away, man. Shit. Good. Source of the deadly 45 Colt rounds. Defendant Hannah Gutierrez Reed, who served with rust armor, was tasked with the safe loading and unloading of blanks and dummy rounds and firearms on set, as well as their cleaning and maintenance. She personally owned the supply she used, commonly referring to the film business as kits. In addition to cleaning supplies and blanks, Defendant Gutierrez Reed had a supply of dummy rounds acquired from her father, Theo Reed. Defendant Gutierrez Reed previously used her kit on the old way. Of the 3 dummy rounds, suppliers to Rust, Defendant Gutierrez Reed supplied approximately 300 dummy rounds of 45 Colt, more than any other supplier. Upon information belief, Defendant Gutierrez Reed's supply of dummy rounds was mixed with live 45 Colt rounds she'd been shooting in her off hours while working as an armorer in the old way. How the hell are you coming up with that conclusion? Also, why does it really matter? Does it really matter? Not particularly. 6 live 45 Colt rounds were found in Ross, the same caliber and round capacity of one of the guns she carried for self-protection. Really? You think Defendant Gutierrez Reed carries a 45 Colt for self-protection? Really? That seems unlikely. I'm going to press X to doubt on that one. Regardless, the Defendant Gutierrez Reed November 9th, 2021 interview with lead detective Hancock, she admitted to bringing dummy round box mixed with the FBI determined to be live ammo. An audio and recording of defendant Hannah Gutierrez Reed with legal counsel present shows Detective Hancock lifting up a photograph of the box defendant Gutierrez Reed loaded the gun with, and the following audio was recorded. DH, but here is my thing that you know. HGR, yeah, it was suspected live rounds in the backs. DH, which matches what you showed me. HGR, yeah. DH, what you brought. HGR, yeah. Well, those are the ones I brought. Insightful. Upon information belief, the FBI found that defendant Gutierrez Reed's fingerprints and DNA on the same dummy round box she supplied from her kit that also contained live rounds with the exact same build characteristics as the deadly rounds she loaded in defendant Baldwin's gun. Plaintiff's single dummy round box supplied to Rust had a handwritten label on both ends in bright blue Sharpie pen on white gaffer tape. Plaintiff's dummy round box was found in a prop truck hundreds of yards away at the time of the shooting. The criminal investigation FBI tested the contents of plaintiff's only dummy rounds box supplied to Rust and determined the contents were in fact dummy rounds and inert. Okay. Additionally, photographic evidence was admitted in the felony criminal conviction of defendant Gutierrez Reed that specifically showing the live rounds were on set of Rust 2 days before the dummy rounds had even been sent to Rust. Okay. In August 2021, defendant Hannah Gutierrez Reed texted plaintiffs that she was desirous to shoot live ammo from the guns on the film of The Old Way. Plaintiffs replied, never shoot live ammo out of a TV gun. Only blanks. It's a serious mistake, always ends in tears. Defendant Gutierrez Reed apparently responded, good to know, I'm still going to shoot mine though. Nice. a firearm chambered in .45 Colt that she had rented to the Old Way Protection Company. Upon information and belief after the shooting of Helena Hutchins, oh, that's why it was sad. Oh, that's why it was sad. Now you tell me. Defendants Gutierrez Reed would photograph and send a privilege waived text message to legal counsel. Well, that's a nice conclusion. And Father Teal Reed, indicating she was still in the possession of live ammo that appeared to match the deadly rounds she had brought to Rust and loaded in defendant Baldwin's gun. Comparison of the deadly Rust ammunition in 1883 reloads. I don't understand why you're doing like some all caps and not all. I don't understand why you're doing some in all caps. Why you're doing like that. I don't get it. I mean, I usually just write mine in all caps. I usually write the header in all caps. Well, I usually write the main header in all caps. And then I write subheaders in just normal sentence structure. Or I think, yeah, okay. So I don't know what you're doing over here in terms of formatting, but that's okay. Reloads are manufactured from previously fired cases. I don't know if that's always true. Well, I suppose to be a reload, it would have to be. To be a reload, it would have to be a previously fired case, now wouldn't it? That would make it a reload. I was thinking to myself, oh, well, that might not necessarily be true for a blank. A blank might use a brand new case, but I suppose a reload, by definition, has to use a previously fired case. That's true. Tautologies are still tautologies. Welcome to my TED Talk. Factory new ammo is made from brand new cases. Tautologies remain tautologies. The visual differences between the two are unmistakable. When the reload case has not been thoroughly cleaned, well, not necessarily, but okay. As was the case with Theo Reed's 1883 loads, the case had each been fired and reloaded several times. You know, I don't know so that you can necessarily say that for sure. I don't know that you can necessarily guarantee that a reloaded round could be visually determined from a non-reloaded round in all cases. Right? I mean, maybe if you got a microscope and something, maybe, but like, could you tell from standard visual inspection? Could you guarantee it? I don't know, man. I don't know about that. You know, I don't know that you could guarantee it, that you'd be able to visually distinguish them, but all right. In the roughly 1,000 instances of providing dummy rounds to entertainment productions, plaintiffs rattle tested each and every dummy round before distributing to use on film set. How do you know that? How do you know that 1,000 times they always did it every other time? How do you know that? He said, if not cleaned. That might have been what he said, to be honest. I remember the sentence, and I don't know what he was saying. It was not, yeah. He might have been saying that. That's one way to read it. I'm confused. Plaintiffs has safely rattle tested and supplied well over 100,000 dummy rounds. So, okay. And distribute to film projects without incident. How do you know that? How do you know there's never... Furthermore, and also, why does it matter? Further, plaintiffs do not shoot .45 Colt, and plaintiffs have never possessed new .45 Colt ammo. How do you know that? And in only one instance held Theodore Reed's 1883 .45 Colt reloads. How do you know that? These are a lot of fun things that you're just saying with no particular basis to believe. The Santa Fe Sheriff's investigation, FBI determined that deadly rounds of rust and 1883 loads were not a match. Theo Reed's 1883 loads were made from brass cases that had been previously reloaded several times. The deadly rounds found in rust were made from brand new cases. Theo Reed's 1883 loads had brass primers, yellow in color. The deadly rust rounds had nickel-plated primers, brightly silver in color. Does he really mean that? Does he really mean the primers? I'm not sure if he really means that or not. The bullets Where were we? The bullets pressed and loaded in the cases were completely different. Theo Reed's 1883 reloads were made from lightweight semi-wad cutter bullets. The deadly rust rounds had full. Is Ian going to read this? Because Ian's going to go nuts. Ian is going to lose his shit. If Ian's not reading this tonight, he should. As our resident firearms guy, this. The 1883 reloads were made from lightweight semi-color bullets. The deadly rust rounds had full weight 255 grain bolts, an easily distinguishable difference between the two. Really? Seriously? Oh yeah, you can definitely easily tell the difference. I don't know, man. Just, I don't know. Yeah. The FBI also determined that Theo Reed's 1883 reloads used a different type of gunpowder than the live rounds found on Rust. The four components needed to manufacture the Rust and 1883 rounds, the case, gunpowder, primer, and bullet, were all found by the FBI to be dissimilar. The manner in which these four components were assembled was also dissimilar. How do you know how they were assembled? Seriously. The Rust ammo was manufactured with a taper crimpling die, while Theo Reed's reloads were made from a roll crimpling die that resulted in a visually obvious distinction. Oh yeah, I'm definitely going to be able to tell as a casual the difference between the crimping. That's definitely going to pop right to my focus. Holy shit. Of the 10 or more data points required to accurately match live rounds, only one similarity existed between the Rust and 1883 rounds. The 45 caliber Colt. All 9 or more possible data similars, you mean of the other ones, were dissimilar, and there's no way that's true. Okay, now, I still don't know how this relates to you. I still don't know how you are involved in this. I understand that the story needs some introduction, right? The story sometimes requires introduction, and the plaintiff doesn't necessarily have to appear right from the first paragraph. You know, sometimes you need a little prelude, but you should have moved out of prelude by now. You should have moved out of prelude at some time ago, to be honest. I'm still not 100% sure how any of this relates to you or your causes of action. Anytime you want to move on will be great. But no, we're not going to move on. We're going to talk about animal cruelty now, because that's relevant somehow. All right, fine. Upon information and belief, defendants individually and collectively violate animal welfare standards by choosing to load and fire the loudest blank round possible with the sole purpose of frightening a horse out of the camera's frame during the Rust filming. What? Upon information and belief, defendants individually and collectively chose to cut corners and knowingly violate animal welfare standards and laws protecting animals. Upon information and belief, defendants knew or individually and collectively that when firing near horses and minor children's, firearms would be loaded with a maximum of a quarter load or less. Why? Why do they know that? Why? Upon information and belief, defendants individually and collectively, including the Rust horse wrangler Doe, loaded and fired the loudest blank possible, a multiple of 4 times the permissible blank round, which would just be a standard load, I guess. Upon information and belief, defendants individually and collectively used an abusive mechanism to generate real on-camera fear in horses' reaction. Upon information and belief, the mindset defendants, individually and collectively, was to get the film in the can at any cost, including quarter-cutting save in the form of abuse. Upon information and belief, defendants were focused on personal financial gain. And now we're getting into the causes of action. We have apparently gone out of the here's what happened stage into the causes of action stage. And the lawyer in me is struggling to figure out what your causes of action are. It's like I read that and nothing is like immediately popping into mind. Normally at this point, like I'd be thinking, oh, it's this, 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 this. And I'm just drawing a blank like a desert prairie, with a windmill and some tumbleweeds. It's all that's in my head right now. And some wind noise with a barn in the back. It's like, what legal causes of action are you picturing? Yeah, I got nothing. All right. False light. Upon information belief, in the years following the shooting, defendants individually and collectively would use their influence. Oh my God. Okay, all right. No, you can't. Okay, guys, look, if you want to sue them for things they said or did after the movie was over, maybe you should have mentioned those things like in the facts pattern, right? If you want to say, oh, they've been saying a lot of mean, false lies. They've been knowingly going out there and besmirching me, and here's what they did. These are completely fictitious, but just for the purposes of discussion, okay? 3 months after the movie was over, they appeared on CNN and they said, his ammo was the worst ammo. That's where I got the ammo on. And 6 months after that, they gave an interview to the New York Times. Down with his ammo. His ammo is the worst. 12 months afterwards, they did a docuseries, The Ammo, where it came from, right? I mean, if you want to sue them for the things they did, maybe you should talk about the things they did. What did they do? I have no idea, because you at no point mentioned it. You just mentioned a lot of things that happened apparently during the movie, and then you're like, oh, now that my causes of action are here, I want to sue you for things that happened afterwards. What the fuck? All right, in the years that followed the shooting, which, this is the first time, in the cause of action, apparently, is when I'm going to mention this for the first time. That's great. Defendants individually and collectively would use their influence and conspire with defendants, Doe, and use a cutthroat industry Hollywood fixers and media to cast plans in a false light. When? When did they do it? In what medium? What show? What news broadcast? What interview? What words? What did they do? What did they say? Help! The film industry was Plant's source of income and predominantly composed of liberals. What? Excuse me. Upon information belief, at direction of defendants, Vanity Fair's Anthony Berzanine wrote a false and misleading article and published Trumper quotes falsely attributed to plaintiffs. Upon information belief, the recent Blake Lively investigation, there is no fucking way that anything good is going to come from this sentence. I know it. You know it. There is no chance whatsoever that as a result of the Blake Lively investigation, there's no way that sentence ends with anything that's going to be helpful for us. Q squared for $5 says on information belief. If I repeat information and belief long enough, I have a case. Ipso facto tautology is tautological. I guess. All right. Let's learn more about Blake Lively. Upon information belief, the recent Blake Lively litigation and press coverage revealed many of defendant Hollywood's fixer tactics. Film industry fixers are playfully represented in episode 2, The Fall of the House of Usher, where the Usher family fixer averted a public relations crisis and fabricated spin using media outlets and influencers that included a scripted version of Anthony Berzanine at Vanity Fair. Upon information and belief, defendant individually and collectively would use their celebrity contacts and connections to launch a national propaganda campaign against plaintiffs. What the fuck am I reading? Upon information and belief, OSHA somehow enters the party. In defendant Baldwin's OSHA recorded interview, he made a number of false and misleading statements, including but not limited to on the day of the shooting. Incidentally, by the way, as long as we're here to learn something of value from this disaster of a lawsuit, as long as we're here to try to learn something, you typically cannot sue people for defamation for statements they make to government officials in the scope of a report, right? So, for example, you can't typically sue somebody for defamation because they said lies about you in a police report, right? Now, you might be able to get them another way, but you can't necessarily get them for the statements themselves, right? You can't get them for defamation. So, because that's considered a privileged report. So you can't sue them because it's privileged. It's privileged in a different sense than attorney-client privilege, but it's privileged. It's protected. So if he lied to OSHA and he said lies about you, you probably can't use this as a basis for defamation. That's, you know. I mean, there's been some discussions as to what days Kenny was actually on set. But we were told very reliable sources that Kenny was on set the day it happened. And that sounds like he's just saying, I believe it to be true, not that I think it is true. It just sounds like this is what I was told. So it sounds like he's saying some hearsay, but he's saying it to OSHA. So, all right. Upon information and belief, defendant Baldwin conspired with defendants and capitalized on his star status to scapegoat the only party not directly tied to the Rust production and insurance policy. Firstly, false stated in his OSHA interview, which you probably can't use, about plaintiffs. We are told he visited, that people saw him there on that day this happened. Kenny, of course, was the one who certain of the people believe he's responsible. Yeah, none of that's coming into court. Defendants individually and collectively, unjustifiably and relentless public harassment campaign occurred for years. In a defendant Baldwin interview, which, by the way, he's going to say it's publicly available, but he's not going to say who it was with or the date of it or anything. It's just an interview that happened somewhere. He once again, on what date, attacked plaintiffs when he asked by the OSHA interview if he ever met Seth Kenny. Defendant Baldwin's replied, Kenny, Kenny, here's the problem. It's like saying, did you ever meet Jeffrey Epstein? Defendants individually and collectively paint plaintiffs under a false light. Upon information and belief and attempt to distribute blame and responsibility for a deadless and injurious shooting, defendants individually and collectively broadcasted false and misleading statements to a national audience. When? In what medium? On what date? Including the false statements found in the OSHA report, which you can't get to. You can't get to Baldwin making the statements to OSHA, and then you can't get to the media for reporting on the statements to OSHA because that's fair report privilege. So you can't sue Baldwin for the statements made to OSHA, and you can't sue the media for reporting the statements that were made to OSHA. A lawyer, I assume, would have been able to tell you this. Where were we on this bullshit? Plaintiff's firearm rental property was brand new and in perfect working order when supplied to Rust. On information belief, and defendant Baldwin's, incidentally, by the way, how does he know that? Is he basing that off what the FBI did? Did he do his own testing? How does he know? On information belief, defendant Baldwin's, and why does it matter? In defendant Baldwin's OSHA interview, he stated that he'd been trained in film with plaintiff's retail film property for nearly a week without issue. In response to OSHA interview question, did it seem like the gun may have had a defect? Baldwin replied, no, because I'd used the gun before, I didn't have a problem. Baldwin further stated the problem with the gun is that there was a live bullet in it. That's the problem. Which is kind of true. That was, in fact, the problem. Upon information and belief, defendant Baldwin switches to and adopted a more aggressive approach to deflect responsibility and claimed plaintiff's rental firearm had a defect of firing without the trigger being pulled, and broadcasted this false statement repeatedly on a national scale. Still, it would have been helpful to mention a time. So I guess that's a statement you can kind of get to. So you want to go with the idea that he said the gun was defective, and therefore it's injurious to your trade. Okay, I mean, I guess that, okay, I guess there's hypothetically a cause of action in there somewhere if a competent attorney rewrote this. First of all, we're going to dump, if Uncivil took this case, which I'm going to need a big check because you sound like a difficult client. Plus, we're going to have to go up against Hollywood and they have big money. So if you want me to represent you, I'm going to need a big check. But if I were to bring this cause of action, first of all, I'm pretty much not mentioning anything that happened on Rust at all. Or if I do, it will be in a very cursory way, right? The entirety of what happened in Rust will be like reduced to a few paragraphs tops, you know, very, very cursory. And then I'm just going to get to like, because it's just background information. And then I'm just going to get to this and go to all these things. I need to rewrite this massively. Your complaint needs to be rewritten massively. It needs to be completely refocused. It needs so much help. I'm going to need a big pile of money. Really big pile of money. Call me. Also, we're going to have to be a lot more targeted in who we're suing. And a lot more specific. Where am I? Upon information belief, defendants individually and collectively broadcasted false statements to besmirch the reputation and condition the firearm rental and adopt a coordinated effort to deflect public ridicule and scorn to salvage prestige, prevent economic loss, and falsely shift blame. Plaintiff's firearms rental property, which was designed in 1873, with a high degree of functionality and reliability. It's the reason the Colt pattern single action army was selected as the official firearm for the state of Arizona. This paragraph, no. Upon information belief, defendants individually and collectively, for the purpose of game and standing in the community, did conspire to paint plaintiffs in a false light. He couldn't have found anybody to represent him? I'll do it. I'm going to need a big pile of money. Really big pile of money. How about $1 million? You know, by the time we're done, it's probably a realistic estimate. Yeah, if you give me $1 million, I will deposit it in a trust account and I will represent you, and then I will start drawing from it. And your cause of action needs help. It needs help. Lots of help. Upon information belief, defendants individually and collectively, for the purpose of gain and standing community, did conspire to paint plaintiffs in a false light. Individually and collectively arranged for defendant Baldwin to interview on Chris Cuomo's nationally publicized talk show and broadcast the falsehood that Seth Kennedy served as Russ' manager, armor mentor, and this false and fabricated conspiracy was blamed. What was the over-under for the pages this reduces to? Yeah, really. It's not necessarily going to be reduced in pages, but it will be completely rewritten. Because if I'm going to sue them for false light, guess what I'm going to sue them? If I'm going to sue them for false light and defamation, guess what I'm going to talk about? Guys, this is not a trick question. This is not a trick question. If I'm going to sue them for false light and defamation, which of these things am I going to talk about? A, what went wrong on the Rust set? B, the public statements that were the false and defamatory things. Do you think I'm going to be talking more about A or more about B? Mm. Yeah. Defendants individually and collectively, for the purpose of gaining standing community, conspired to paint plaintiffs, arranged for defendant Baldwin, and broadcast the false that served as the producer. Upon information belief, Rust director Joel Souza made the decision to hire Hannah Gutierrez Reed. Who cares? During the same week of Chris Cuomo's broadcast, which week? It would have been nice. Defendant Baldwin provides CNN with a nationally broadcast interview. Date, time, with whom, where he once again shifted blame from his self-defense to paint plaintiffs in a false and misleading light, without facts and support, mused aloud in the interview, where plaintiff Safe Kenny had commingled live ammunition with blanks. Upon information and belief, defense enlisted the services of online YouTube channels. If any of the defendants enlisted the services of any of the YouTube channels, where is my check? Do I have to sue Hollywood for breach of contract now? They were enlisting. Where my money, yo? Where my money at? And plaintiff plays in a false and negative light. I see a legal citation. I see a legal citation. A legal citation in a complaint is unusual. So I laugh. Yeah, it's like, in the complaint, it's unusual to do a citation unless there's a very specific reason you're doing it. I actually had to do it recently. I actually had to put a citation in a complaint, and it's just okay. This is great. The reason, incidentally, by the way, I had to do it was because there was a cause of action for which the statute says there's one statute of limitations, but the case law changed it. So I had to cite the case law so that it would show that it was within the statute. So okay. Additionally, as part of defendants' campaign to rebuild the standing in the public eye, also enlist services or through intermediaries for paid online trolls. Again, I am not getting these checks. And broadcasted messages directed towards diminishing plaintiff standing, and once again paying plaintiffs. Is he going to sue me? Can I represent him, or is he about to sue me? If I wind up in this cause of action, I'm surprised at this point I haven't wound up in this cause of action. If he really believes we're being paid to spread these lies, why are we not in this cause of action? Am I going to get sued? What's happening? Upon information belief, defense individually and collectively attack plaintiffs on a national broadcast level and have every opportunity to misdirect negative attention from themselves and cast plaintiffs in a highly offensive light that's caused blah, blah, blah. And then he cites a case without telling me why he's citing it. Like, why are you citing this? Are you citing it for like this, what the cause of action is? I don't even know. Upon information belief, on January 9, 2025, defendant Baldwin filed a lawsuit in the First Judicial District Court of Santa Fe against the district attorney's office. In doing so, spread false and malicious accusations. Okay, guys, you already know the answer to this one. Defendant Baldwin filed a lawsuit in which he spreaded false accusations. Okay, kids, you know the answer to this. You guys have been part of the lawsuit game long enough. Can I sue someone for what they said in a lawsuit? Can I sue them for the defamation as a result of what they put in their lawsuit? You know the answer to this. I know the answer to this. Ooh. Through defendants' contacts in the media with a broader goal of saving public sentiment. Upon information and belief, the extensive criminal investigation, resulting trials, and sworn testimony, defendant Baldwin was made aware plaintiffs did not purposefully or inadvertently supply the Rust producer with live ammunition. At large, and in defense lawsuit, when, like, this knowledge would only matter if he's made statements afterwards, he scapegoats others, and specifically plaintiffs is false and maliciously stated in paragraph 38 of his lawsuit Both Zachary and Gutierrez Reed came with strong recommendations from the producer's ammo company, Seth Cunny. This false and misleading accusation is akin to shooting two people with one bullet. First of all, legally, no. Second of all, really, you had to go with that phrasing in this case? Seriously? Of all the possible phrasing you could do, of all the possible things you could have said, you decided to go with shooting two people with one bullet? Really? Of all the possible phrasings you could go, that was the one you needed, man. No other analogy would do. No other, I absolutely positively need this analogy. No other analogy will suit my purpose. It must be this and only this. Holy shit. Defendant Baldwin, in total disregard for truth, managed 3 and false statements. At this point, if you don't get sanctions by the judge, I will be amazed. You're pro se though, so that will help a lot. If an attorney wrote this, heaven forbid, if an attorney wrote this, but you're a pro se, so you probably won't get sanctioned out of the gates. Defendant Baldwin created a false and underhanded suggestion that Gutierrez Reed was hired and worked on Ross due to Plant's strong recommendation. Plants did not, nor are they known, Gutierrez Reed's set work capabilities or lack thereof. Neither they worked with or trained Gutierrez Reed to work as an armorer. He likes those capital letters for the job titles, man. Defendant Baldwin broadcast to the media and made a false and underhanded statement in his lawsuit that Plants were the sole supplier of ammo to his Russ. Upon information belief, the extensive criminal investigation and resulting trials and sworn testimony informed Baldwin 3 dummy rounds. So, did he know it was false at the time he said it? Yeah. Is this frivolous? Despite himself, no, it is not frivolous, because there is a cause of action burning deep. He did his best to hide it, God knows, but there is a potential cause of action. There's like one sentence in this thing that is a basis for yeah. So is it frivolous? There's one sentence in it that's not frivolous. So what he needs to do is withdraw this immediately. He needs to withdraw this immediately and have someone filed amended as, yeah, if he hired me, I would file a first amended as fast as my little fingers could type. It would not be in any sense a complete. Okay. I don't have time for that. Okay. If he hired me, I'm going to be panic filing. Okay. I'm going to be panic filing a First Amendment. It is going to be it's going to be thin. It'll be okay. It's going to be thin. It's not going to have everything because I need to get anything on file before the court just starts laughing in everyone's face. So I'm going to panic file a First Amended, and then I will at some later point file a real Second Amended. And yeah, holy shit. Yeah, that's what I'm doing. I'm panic filing. That's always great. Upon information belief due to the extensive criminal record and the resulting trials, including sworn testimony, defendant Baldwin knew or should have known that ammo Oxford's English Dictionary defines ammunition as, oh my God. Ammunition as defined by maybe if I paid him to be his lawyer. I'll pay you $1,000 to let me fix this bullshit. Ammunition defined by the ATF has both a propellant charge and a projectile, most commonly a bullet, steel or lead shot. Defendant Baldwin falsely and maliciously alleged the plants were the supplier of live ammo. In paragraph 77 of his lawsuit, he falsely alleged that plants were a supplier of live rounds to Rust, or there was increased evidence that Plant had inadvertently been a source of live ammo, and made the false suggestion that more evidence emerged that Seth Kenny, a third-party ammo supplier, may have been the source of a live round. You think if we filed a sworn declaration to the court that, this was written by a troll and not really written by Seth Kenny, and it should be stricken from the public docket and buried in the memory archives, you think that could work? How do we remove it from the public docket? That's a good question. How do we? Yeah, all right. Defendant Baldwin knew or should have known that criminal investigation found no evidence linking Plants to the deadly round of ammunition that defendant Baldwin fired. Instead, Santa Fe criminal investigation cleared Plants and found the live ammo Plants was entirely dissimilar to that found in Rust. Plaintiff Baldwin continues through his media release with false and misleading statements, stating that Plants supplied ammo and therefore a source of deadly rounds. Defendant Baldwin's lawsuit made additional false allegations. Plants were made aware of lapses. Another completely false allegation. Again, in the paragraph 213 of the lawsuit, we're still suing over a lawsuit. That's great news. Here's what my revised first cause of action. Here's what my first amended complaint will have a lot less of. It will have a lot less mentions of lawsuits that Baldwin filed. Lot fewer mentions of that. It will also have a lot fewer mentions of statements he told to OSHA. Yeah. He falsely and maliciously stated Kenny had all revealed to Detective Hancock that he may have been the source of the live bolt that killed Hutchins. Upon information belief, defendant Baldwin's media release false statements were done intentionally to harm plaintiffs in the media, false film industry, and public view for the purpose of deflection and scapegoating. Defendant Baldwin's false narrative is unsupported by fact and aimed to avoid a painful truth. That again, defendant Baldwin knowingly took the firearm from a member of crew he knew was not authorized without performing or observing a safety check of the firearm. As defendant Baldwin stated in his interview, "Give me the biggest gun you've got." What is this sentence? Is this one sentence or did I miss? No, this is a sentence. Okay, I'm going to give this sentence again. I'm going to give this sentence another try because this sentence is a crime against humanity. I'm going to give it another shot. Defendant Baldwin's false narrative is unsupported by fact and aimed to avoid a painful, simple truth. That again, defendant Baldwin knowingly took the firearm from a member of crew he knew was not authorized to handle firearms on set, and without performing or observing a safety check of the firearm with authorized crew, immediately pointed and fired the unmodified, brand new, and as defendant Baldwin stated in his October 21st, 2021 interview with detective stated, quote, "Give me the biggest gun you've got," unquote, fired the largest gun he could get his hands on to deadly injurious effect. I would like a round of applause at this point for making it through that sentence. It may have been incoherent, but I read it from start to finish, and I deserve and demand your admiration. Upon information and belief, plaintiffs have suffered at the hands of defendant, individually and collectively, by unreasonable and highly objective media, broadcast publicly that attributes characteristics, conduct, or beliefs that place plaintiffs before a false position, therefore a viable cause of action, citing the second state retorts. Second cause of action, conversion. Okay. Is this going to be because they didn't use your gun exactly? I'm trying to think how is he going to get to conversion? This is what I'm trying to figure out now. Is it going to be because they didn't follow the contract, and because they went outside the contract, they therefore used it without authorization, and therefore that's conversion? Is that what we're going for? That's not conversion, by the way. But that I feel that that's where we're going, because that's the only thing that kind of makes sense. All right. Defendants individually and collectively agreed and allowed Baldwin to, without consent of plaintiffs, in direct opposition to plaintiffs' right and interest, take plaintiffs' rental firearm property. You loaned it to them. Draw the firearm, and without checking the firearm's safe condition, manipulate the firearm's cause of action, shooting and killing Helena Hutchins. As your hypothetical attorney, sir, we're going to be dropping the conversion cause of action. Not so much with that one. No. Yeah, no, we're not doing conversion. No. Upon information belief, defendants individually and collectively benefited from and continued to benefit from the aforementioned illegal and unauthorized use of the firearm and did commit the illegal act of animal cruelty. We are not filing this cause of action. If anyone ever asks, we are going to deny that we ever filed this cause of action. I may claim that conversion. I've never heard of this strange word, conversion. I don't even understand that word. That must be something that you made up. I have no idea what conversion is. That must be some sort of fake news bullshit. I've never heard of that. I've been a lawyer for almost 20 years. I have no idea what the fuck you're talking about. Upon information and belief, defendants individually and collectively contribute to or directly caused manslaughter, an injury born of cost-cutting financial gain with illegal and authorized use of firearm property. Upon information and belief, they violated New Mexico with reckless and unauthorized use of firearm rental property. Upon information and belief, individual and collective, lawful and temporary possession of property, and did delve into unauthorized and illegal use contrary to the scope of the authority. No. Upon information and belief, defendants individually and collectively used plaintiff's firearm property in unauthorized manner and scope, seriously violating plaintiff's right of control. Upon information and result of defendant's criminal conversion of plaintiff's property to kill and maim, plaintiff suffers ongoing emotional distress. Is there any portion of my wall I can beat my head against? Hold on. I'm going to have to take down my painting to do this. It's been a while since we've done this. Hold on. I'm going to have to take down my painting or something, because this is... Yeah, I don't have enough wall. All right, hold on. Yep. No. Okay. Yeah, okay. Yeah, not so much. No, we're not going to be suing for that either. Unjust enrichment. Plaintiffs and defendants and plaintiffs entered into a rental contract and purchase agreement. Plaintiffs did not provide defendants with goods and services set forth, did provide them with goods and services. Defendants were to pay for and return the rental property, and have not. As a result of the unauthorized illegal acts, the rental property were seized. You don't need unjust enrichment. Breach of contract will be fine. Upon information and belief, defendant's production and filming of Rust has been completed, and the Rust film is being broadcast and marketed for sale without just compensation. Upon information and belief, defendants individually collect. You really want to sue for the cost of the gun? I'm not saying you can't. I'm not saying you can't sue for the cost of the gun. Your property has in fact not been returned. But really? All right, really? I don't know, ma'am. I don't know. I'm not sure that as your lawyer, I would advise that cause of action. I think maybe just let that one go. Upon information believed defendants individually and collectively benefited from the use of property and failed to or refused to pay the outstanding invoices up to and including the initial 5-week rental and any extended rental due when plaintiff's property is held in evidence. Plaintiffs are due just compensation. Fourth cause of action, tortious interference. A film production's property departments as qualified members are the only film crew authorized to work with actors, stunt doubles, and body double stand-ins with firearms and properties. Why? Why is that true? Why are they the only ones authorized? Is it in your contract? Does it say that contractually? Is there a law? Why is it true? Why are they the only ones authorized? Are you just simply saying it's the best practices? What the? Property master Sarah Zachary serves as both head of Russ Property as well as plaintiff's employee's agent. Sarah Zachary, as Russ Property Manager, has authority and did select, based on existing agreements with plaintiff, to source property used in the production of Rust. Okay. Dual agency working relationship between property master and prop house supplier is common, satisfies federal firearms law, and common lasts the entirety of one's career. Sure, why not? Upon information belief, defendants individually and collectively were aware the plaintiffs had agency with Sarah Zachary and rental agreement contract with the defendants and did rent them from plaintiffs. Upon information belief, defendants, including defendant Joel Souza, defendant Gabriel Pickle, and defendant Hannah Gutierrez Reeds and Sarah Zachary, individually and collectively had Zoom conference calls with plaintiff to establish the inventory and timelines for delivery through dual agent Sarah Zachary through the filming. Upon information belief, defendants individually and collectively, please stop saying that, used plaintiff's rental property to film Russ for 12 days on the total 21 film day shoot. Upon information belief, defendants individually and collectively did interfere with safe operation of plaintiff's existing business contracts. How? How did they interfere? And without authority, breached all manners of contract and agreement, which would be a breach of contract, not tort. Used plaintiff's rental policy deadly and injurious results, which is not tortious interference, resulting in Santa Fe law enforcement of property. It's negligence, I guess, but upon information belief, defendants individually and collectively received a sale order of blank ammunition for using in Rust from plaintiffs and did use the blank ammunition for 12 days of the 21 days and due defense interference with safe execution of the business agreement and rental contract, used it to deadly and injurious result. No, absolutely not. We're not suing for this either. Yeah, no. We're not suing for tortious interference either. No. No, we're not suing for that either. No, absolutely not. Upon information belief, defendants individually and collectively knowingly jeopardize the safe use of plaintiff's rental. Maybe that's why he's representing himself. Maybe he's representing himself because lawyers like me are like, no, we're not suing for that. We're not suing for that. Maybe he couldn't find anyone who wanted to represent him on these causes of action. Yeah, I'm like, no, we're not doing that. No. Upon information belief, defendants individually and collectively unauthorized and illegal acts have caused interruption and interference with plaintiff's existing business. Absolutely not. We're definitely not suing for any of that. Individually and collectively, due to illegal actions, caused the seizure. And then we're into punitive damages. Okay, so all right. Your causes of action suck. You might have a breach of contract action depending on what your contract requires. You might have a breach of contract action. You might have a defamation cause of action. Not for the reports they gave to the police or to OSHA or in the lawsuits, but for other statements they made to media. So you might, and depending on when they said them, is going to be critical, right? So the timing of the statements is going to matter. So you might have a, and also I might even be able to like get to defamation using non-public figure because this isn't a well-known business and he's not a public person. So unless state law requires you to prove malice in for a company because maybe the New Mexico standard requires it, I'll just plead it a simple negligence defamation, unless I have to for state law reasons. Plead it otherwise. So I'll plead it a simple negligence defamation. Makes my burden of proof a fuck lot easier. And then I'll sue for the statements made when they should have known. So later statements would be helpful than earlier statements. And maybe there's a breach of contract in there somewhere because they were contractually required to follow certain things, and we can show negligence. You know, if we can show that the breach of contract, maybe we can bootstrap a negligence claim because of their failure because of the duty imposed by the contract, the contract imposed a duty, and because of that, we can try to get a negligence cause of action out of that. And false light. Yeah, that's basically what I've got, and not so much with the infliction of emotional distress. Not as a cause of action, not a chance. I might put it in damages, but not as a cause of action. And that's my proposal. I'm going to need to get started. To get started, I'm going to need about $100,000 to get started, because it's gonna yeah. Yeah. Please incorporate herein by reference each and every allegation, which in the paragraphs, at all times this complaint defendant was malicious, willful, or wanton to the extent is acting as an agent, conduct, blah, blah, blah. Therefore, we want compensatory damages, civil remedies, punitive, and okay. Seth, you need help. Seth, you need a lot of help. Seth, do you have like $50,000? Because I mean, just to get through, I'm going to need $50,000 to like get through the initial pleadings, probably, because it's Hollywood. It's going to get complicated. Do you have like $50,000? He did thoughtfully give me his address, phone number, and email address. So I could, yeah, I guess I could look up the rules on soliciting, whether or not I can actually message. What are the rules? And I guess I have to follow New Mexico's rules on soliciting, because is he from New Mexico? Actually, yeah, because where is he? Which state's ethics rules do I have to follow? This is a good question. Hold on. Is it malicious for even like even is New Mexico required malicious for every defamation or this kind of defamation? Yeah, if I'm stuck with the higher standard, I'm gonna have a bad day. But if New Mexico requires maliciousness for the because it's a business or for some other reason, yeah, that's gonna be challenging at best. I'll try, but that's a tough cause of action. So he's a resident of Arizona, but he's filing in New Mexico. Okay, but I'm soliciting him in Arizona, so I think the relevant ethics rules are in Arizona, I think. So yeah, I'll go read the relevant ethics rules and figure out whether or not I can ethically like solicit him. I think I can. I just can't solicit him. I can solicit him in writing. I don't think I can solicit him by phone. I think I can solicit him in writing. But if I want to, I'll look into it. Yeah. So yeah, I think the Arizona ethics rules are the ones that apply, even though I'm going to be filing in New Mexico. You know, for the sake of it, let's just make sure I'm following the ethics rules in Arizona, New Mexico, and Texas all at the same time, just to cover all my bases. I'll just go to the least common denominator, so I won't be sad, and I'll just cover them all. That's fine. So, of course, if he wants to contact me, he can. So, you know, if you're out there and you want to drop me an email, my email address is in the, you know, contact me page, and you need help. You need help. Here's your free legal advice. Get help. Get help from somebody quickly, rapidly. Oh, Lord. New Mexico has strict laws against solicitation, direct solicitation clients for injury. Prohibits paying for referrals. Yeah, this is an injury. Yeah, so see, you got to look it up, right? What are the rules for soliciting? Like, you can't, there are rules. Like, you can't, I'll look it up. I'll look it up. I'm not going to go on the Google summary. I'll look it up. What are exactly the ethics rules here? And I'll get back to you. Like, I'm not even sure which ethics rules apply, right? It's like, yeah, so I'll look it up and I'll get back to you on that one. Oh, Lord. Well, this has been a whole pile of stupid. This has been incredibly, incredibly stupid. I hope Ian covers this because this is bad. I mean, seriously, he could have gone to ChatGPT and, I mean, seriously, would have done better by a lot. I don't know what he's doing. Yeah. New Mexico, isn't that also the one that decided to abolish spousal privilege? I think it was New Mexico. Their Supreme Court decided to abolish spousal privilege because it was old and antiquated. Fuck. Yeah, so it's New Mexico. Yeah, states do weird things, man. States do weird shit. I just know the big ethics rules. As long as you stay like clear of the big ethics rules, like the more minor ethics rules, you can kind of have to go out of your way, right? You kind of like have to really dick somebody over. It's not like to say that they aren't real, but like they're not the ones the bar is going to really care about. So like, if you infringe one of the more minor ethics rules, no one's going to really bat a huge eye, and especially but so just avoid the big ones. The big ones are literally don't have sex with the client after they become the client. Okay, don't fuck the client, literally. Don't steal the client's money. Don't divulge the client's secrets. And have the barest minimum of competence. Those kind of big ones. And as long as you follow the big ones, everything else you'll be okay, right? It's like, and can you please just not literally have sex with the client and steal their money? That would be great. Right? So, yeah. Good times. And Joe Basdy, sleep with Casey Anthony. The key there is always when, right? If they slept with so-and-so, when did they sleep with them? That's the key, right? Because on the ethics rules, but let's not, yeah. New Mexico is revisiting spousal privilege. They should, because it was a stupid decision by their Supreme Court. It was a stupid ass decision to abolish. That was a fucking retarded decision. I don't. It's old and antiquated. Fuck you. Yeah, that was a stupid decision. And it wasn't even like New Mexico Supreme Court just did it because they felt like doing it because they feel like it had this drip of superiority all over it too. It had this drip of like, we know better. We're the best. We're the ethical high bar. It's like, fuck you, Supreme Court. Yeah. Lord have mercy. All right. Well, I guess I'm going to go ahead and sign off for now. This has been fun. What else am I doing? I went to the gym today. That was good. I was 7th place this last month for gym workouts. That was good. Today was just like accessory work. No major lifts today. Oh yeah. And then I have a hearing tomorrow for my client with the judge. That's exciting. So I'm looking forward to that. And yeah, we'll go over that. All right. I'm going to talk to you later. Bye. How was the stew? The stew turned out okay, but it turns out I'm not really a fan of smoked paprika. So I put smoked paprika in the dish, and it turns out I'm not really a fan. So fortunately, I didn't like to put too much of it in. So it's not like completely inedible, but I kind of wish I hadn't. So if you like smoked paprika, I'm sure it's great. But as it turns out, I don't like smoked paprika. So wish I hadn't done that. But other than that, the dish turned out okay. It's still salvageable. Just not where I wish it could be. So, whatever. All right. Oh, well, we learned something by doing. Next time, hope all's well. Cheers for now. Will I be an auctioneer? You bet your ass I'll be an auctioneer. I would be insulted. I'd be insulted if Uncle didn't let me be an auctioneer. It is my pride and joy. Of course I'm going to be an auctioneer. I will sell you a rock. I will sell you a picture of a rock. I will send you prayers on the wind. I'm very, very good at it. We can do Q&A if you have any other questions. I'm not really in a rush to get anywhere. What else you guys want to talk about? Yeah, I mean, it was basic smoked paprika. It was just like Walmart brand, so maybe it's a brand thing, but not for me. An NFT picture of a rock. There you go. Yeah, I will absolutely sell you an NFT of a rock. 100%. That sounds good. Sure. Yeah. All right.